Hey guys, tonight I need to tell you about 1 hour. Not 1 year, not 1 month, 1 hour. That is how much time Mary Lincoln had between the moment she learned there was a legal proceeding against her and the moment she was standing inside it. A man she had known for 20 years came to her hotel room in Chicago at 1 o'clock in the afternoon on Wednesday, the 19th of May, 1875. Court convened at 2. By late afternoon, a jury of 12 businessmen had found her insane. By the next morning, she was in an asylum 40 miles west of the city. I am going to give you the outcome now, because this channel does not build suspense by hiding what happened. The jury deliberated for about 10 minutes. The verdict form they signed recorded that Mary Lincoln was insane and was a fit person to be sent to a state hospital for the insane. That same form recorded that she showed no suicidal tendency. Within hours of signing it, she walked out of her hotel and went from drugstore to drugstore in downtown Chicago, trying to buy enough laudanum to kill herself. 13 months later, a second jury in the same court reversed the first one. The man who filed the petition was her son. Before we go any further, I need you to hold on to 3 things. Do not try to interpret them yet. Just put them somewhere you can reach. The first is a pair of numbers, 17 and 0. 17 witnesses testified against Mary Lincoln that afternoon. Her lawyer called none. The second is a piece of paper, not a dramatic document, a printed county form with blank spaces on it, the kind a clerk keeps in a drawer by the 100. The jury did not write out their reasoning. They filled in the blanks. The third is a name that has almost nothing to do with Mary Lincoln and everything to do with what happened to her. Elizabeth Packard. Hold that name. We will come back for it. Now, a disclaimer, because it matters more here than in almost any case we have looked at. This is not a video about whether Mary Lincoln was mentally ill. I am not going to tell you she was perfectly well, because the evidence does not support that, and anyone who tells you it does is selling you a cleaner story than the record contains. I am also not going to tell you she was mad. The men who said so in that courtroom had, with one exception, never examined her. And the one physician who had examined her was describing symptoms that 2 doctors, 124 years later, would identify as something else entirely. The question in front of us is narrower and colder than her diagnosis. It is this. Illinois had recently passed a law specifically designed to stop families from disappearing inconvenient relatives. That law, as legal historians describe it, required a jury. It required counsel. It required a public hearing. Mary Lincoln got all 3, and it took 1 afternoon. So the question is not whether the system was broken. The question is whether the system, working exactly as designed, running at full speed with every protection switched on, was capable of finding out the truth about a woman in 1 afternoon. Hold that. We are going to test it. If this is the kind of case you came here for, the version where the paperwork turns out to be the story, then subscribe. The next time we open a county file like this one, you are already in the room. We cannot start in that courtroom. Nothing that happened there makes sense unless you understand what the previous 10 years had done to this woman and what the previous 15 years had done to the law. We will get to both. But I want you inside the hour first, because the hour is the thing everyone skips, and the hour is where the case is actually decided. So, 1 o'clock in the afternoon, the Grand Pacific Hotel, Chicago. Mary Lincoln had been living there since the middle of March. She was 56 years old. She had been a widow for 10 years and 1 month. She had buried 3 of her 4 sons. She kept the shades in her rooms drawn. And she had recently developed a habit her son found alarming. She carried her entire fortune on her body, in United States government bonds, sewn into the pockets of her petticoat. Detectives hired by that son had watched her doing it the previous day. The amount was somewhere between $56,000 and $57,000, depending on which account you read. And I will keep saying somewhere between because the sources do not agree, and I am not going to pretend they do. The man who knocked was Leonard Swett. Swett had ridden the 8th Judicial Circuit in Illinois with Abraham Lincoln. He had helped manage Lincoln's nomination in 1860. He had been in the Lincoln's house. He was, in the plainest sense of the phrase, an old friend of the family, and he was there that afternoon as the agent of the petitioner. We know what happened in that room in unusual detail, because Swett wrote his own account of it shortly afterward, and that account survives. She was pleased to see him. He wrote that she seemed cheerful and glad he had come. He asked her to sit down. Then he told her he had bad news. He said that her friends had come to the conclusion that everything she had been through had been too much for her, and that her troubles had produced mental disease. She cut straight through it. She said, "You mean to say I am crazy, then, do you?" And Swett, to his credit, did not soften it. He said yes. He told her that was what her friends all believed. She said she was obliged to him, but that she was abundantly able to take care of herself. Sit with that exchange for a moment, because it is the clearest thing anyone said all day. She was told she was insane, and she answered in 3 sentences that were direct, grammatical, unhysterical, and entirely to the point. She asked to see Robert. Swett told her the men who had reached this conclusion included Judge David Davis, who had administered her husband's estate, and John Todd Stewart, her own cousin, who had been her husband's first law partner. He had letters from physicians with him, and he produced them. And here she made an objection. She told him those doctors had never examined her. I want you to hold that in your hand for a moment, not as a legal argument, just as a fact about a room. 1 hour before her trial, with no lawyer, no notice, and no preparation, Mary Lincoln identified the single strongest defect in the case against her. Her lawyer would not raise it. Swett then told her the rest. 2 officers were waiting downstairs. They had authority to take her by force. He said that unless she came with him, he would either have to seize her himself or turn her over to them, and that they were prepared to use handcuffs. She said he was her husband's friend, and that he had come to lock her up in an asylum. He would not leave the room while she dressed. He wrote that he was afraid she might go out a window. Then she went with him to court. Now, 2 o'clock. The county court of Cook County, Judge M.R.M. Wallace on the bench, who had been elected to that seat some years earlier. The petition had been filed that morning. It valued her estate at not exceeding $75,000. 2 lawyers appeared for the petitioner. Benjamin Ayer made the opening statement to the jury. Swett, who had spent the previous days assembling the case, sat with him. 1 lawyer appeared for Mary Lincoln. His name was Isaac Newton Arnold. He had been a congressman. He had known Abraham Lincoln for decades and would later write his biography. He had been chosen by Swett. She had no say in who represented her. The man prosecuting her case picked her defense counsel, and by more than one account, Arnold hesitated when he was asked, and by more than one account, Swett told him to go and do his duty. I want to flag that particular exchange, because the wording that gets quoted for it comes to us through a 1959 popular reconstruction whose authors admitted they were filling gaps. The substance is well attested. The exact sentences are not. I am not going to put words in Leonard Sweat's mouth to make him sound worse than the documented facts already make him sound. Because here is the documented fact. Arnold took the case, believing his client was insane. Now I have to tell you something about the record itself, and it changes how you should listen to everything that follows. The transcript of this trial is gone. Not sealed, not restricted. Gone. Nobody knows when it disappeared or how. What survives is the court file, the petition, the physician's certificates, the writ, the verdict form, the order. And alongside it, the Chicago newspapers of the next morning, which sent reporters and printed what they heard. So when I describe the testimony, I am describing it at one remove, through men writing at speed for an evening deadline in a city that was selling papers on this story. I will tell you when a line is solid, and I will tell you when it is not. But you should know from the start that the record of what was decided survived, and the record of what was said did not. Keep that asymmetry in mind. It will matter later. 17 witnesses were called. We know the composition of that group from the scholarship. 5 worked at the Grand Pacific Hotel. 1 was an agent of a shipping company. 5 were merchants, jewelers, and tradesmen who had sold her things. 5 were physicians. The 17th was her son. The first witness was Dr. Willis Danforth. And Danforth is the most important witness of the afternoon, because he is the only one who had actually treated her. He had seen her professionally in 1873 for fever and what he called a nervous derangement of the head, and again in November of 1874. What he testified to was this. She had told him someone was at work at her head. She had told him an Indian spirit was removing the bones from her face and pulling wires out of her eyes, and by one account she specified the left eye in particular. She had told him someone was taking steel springs out of her head. She had told him she heard raps on a table announcing the hour of her death, and that her husband had told her she would die soon. Read that list again, slowly, because I am going to come back to every item on it in the last part of this video, and none of it is going to mean what it means right now. The physicians who followed him had a different relationship to the evidence. They had not examined her for this proceeding. What they had done was attend a private conference 4 days earlier, on the 15th of May. 6 doctors sat in a room. Robert Lincoln told them what his mother had been doing. On that basis, they agreed she was insane. One of them, Dr. Richard Patterson, had written the day before the trial that on the facts disclosed at that conference, she was insane and a fit person to be sent to the state hospital. Patterson owned a private asylum. She would be in it by the following evening. Then came the merchants. And this is the part of the case that a modern audience finds most familiar and most uncomfortable, because it is the part that would be used against a woman today. She had spent $600 on lace curtains. She had spent $450 on 3 watches. There was testimony about jewelry, and about perfumes and soaps, and about gloves and handkerchiefs bought by the dozen. There was testimony that ran, in the phrasing of one account, chiefly to the vast accumulation of unmade dress goods in her rooms. She was buying and not using what she bought. The trunks were reported to be sitting unopened. The curtain detail is the one that does the work, and I want to be precise about why. She was living in a hotel. She bought $600 of lace curtains for windows she did not own, in rooms she was renting, and the curtains stayed in their wrapping. That is genuinely strange behavior. I am not going to explain it away for you. $600 in 1875 was about a fifth of her entire annual pension, spent on window dressing for windows that were not hers. And at the same time, she was carrying somewhere between $56,000 and $57,000 in government bonds sewn into her clothing. That is roughly 19 years of that pension. On her body, in a hotel, in a city that had burned to the ground 4 years earlier. Both of those facts are true at once. A woman terrified of losing her money, and a woman spending it on things she never opened. If you are looking for the strongest evidence the petitioner had, it is not the Indian spirit, and it is not the wires. It is the arithmetic of the curtains against the arithmetic of the petticoat. The hotel staff came next. A maid said Mary Lincoln had complained of voices speaking to her through the wall. There was testimony about the 1st of April. She had come into the hotel corridor not fully dressed and got into the elevator. When Robert took hold of her to bring her back, she screamed that he was going to murder her. And then there is the line from the housekeeper, which survives, and which I think is the most revealing sentence anybody spoke in that courtroom. She said Mary Lincoln was often nervous and excitable, and then she said she was not like ladies in general. That is the whole case in 9 words, and the witness did not know she was saying it. Not dangerous, not raving, not a threat to herself or anyone else, not like ladies in general. Then Robert Lincoln took the stand. He was 31 years old. He was a practicing attorney in that city. He was the only surviving child of Abraham and Mary Lincoln, and the reporters in the room recorded that he wept, that his face was pale and his eyes red. He testified that his mother had been of unsound mind since the death of his father and had been irresponsible for the past 10 years. He said he had no doubt she was insane and that she had long been a source of anxiety to him. He described her as exceedingly kind to him and unmanageable, and said she would never take his advice. He testified about the trunks filled with dresses and valuables of which she made no use. He testified about the poisoning fear on the train from Florida and the voices through the walls. I am not going to tell you Robert Lincoln was a villain, and I want to be careful here, because the easy version of this story needs him to be one. He had stood at his father's deathbed. He had buried his brother Tad less than 4 years earlier. He had a wife and small children and a law practice, and a mother who was walking around Chicago with the family fortune sewn into her underwear. 6 physicians in a private room had told him, in his own written words, that by delaying any longer, he was making himself morally responsible for some very probable tragedy which might occur at any moment. He believed them. He acted. And here is the fact that sits under all of it, the one that is easy to miss. Illinois law did not require him to go to court at all. Voluntary admission to a private institution needed no proceeding, no jury, and no verdict. Robert went to court because he expected his mother to refuse. The courtroom was not a necessity. It was a choice, made because the alternative required her consent. There is one more piece of the day I have to put in front of you, and it is the least dramatic and the most damaging. The physicians did not all appear in person. Certificates were produced. Dr. Ralph Isham, the family's own Chicago physician, had put in writing that she was insane and a fit subject for hospital treatment. Patterson had put in writing, the day before, that on the facts disclosed at the conference, she was insane. Notice the phrasing, on the facts disclosed. That is a doctor telling you, in his own words, in a document written to be relied on in court, that he is giving an opinion on a description rather than on a patient. He is not concealing it. He is stating his terms. And the court accepted it, because in 1875, that was a normal thing for a court to accept. Mary Lincoln had made that exact objection an hour earlier, standing in a hotel room with no lawyer. The men who wrote those certificates had already conceded her point in writing, and nobody in the courtroom read it back to them. Now, Isaac Arnold. He did not cross-examine the witnesses. By one account, he asked the doctors only to confirm their qualifications, which is to say that the only questions Mary Lincoln's lawyer asked all afternoon had the effect of strengthening the credentials of the men testifying against her. He called no witnesses, not her sister, not her cousin, not the physicians who had actually treated her over the years, not the friends who had seen her in Florida that winter, not one. He did not put his client on the stand. Nothing in the law prevented it, and she had already shown sweat, in a hotel room with no preparation, that she could answer a hard question in one clean sentence. He did not raise the objection his client had raised to Sweat an hour before, that the physicians had not examined her. He did not ask for a continuance. She had been served at 1 o'clock for a 2 o'clock trial. There is no record of anyone asking the court for a single additional day, and he did not contest the second half of what the jury was being asked to find. Even if you grant that she was ill, whether she needed to be confined was a separate question, and there was a route to care that did not require a verdict at all. That alternative was never put to the jury, because the only person in the room whose job was to put it there did not believe in his client's case. Now the 12 men. I have to be careful here, because a full list of the jury circulates, and most of it comes from a 1959 popular book whose authors admitted they reconstructed what they could not document. I am not going to read you 11 names I cannot stand behind. 3 of them are corroborated independently, and 3 is enough. The foreman was Lyman Gage. He was a Chicago bank official who would go on to be president of the First National Bank of Chicago and then Secretary of the Treasury of the United States under 2 administrations. Charles Farwell was a wholesale dry goods man and, at that moment, a sitting member of Congress. He would go on to the United States Senate. Henry Duran was in wholesale groceries. I want you to see the shape of that panel, because it is not a random slice of Cook County. This was a jury of the city's commercial class, bankers and wholesalers, the men who extended credit in Chicago and the men who sold goods at scale. And the case they were being asked to decide was, in its central evidentiary movement, a case about a woman who bought too much. 5 of the 17 witnesses were merchants and jewelers and tradesmen. They came into court and described a customer. The men judging whether that customer was insane were, professionally, the people who sold to customers like her and the people who financed the men who sold to her. They knew exactly what a good account looked like and exactly what an irrational one looked like. And they were being handed a woman who had spent $600 on curtains for a hotel room while carrying $56,000 in bonds against her skin. I am not suggesting anyone was corrupt. There is no evidence of that, and I do not believe it. I am telling you something narrower. If you wanted 12 men in the city of Chicago, most likely to look at Mary Lincoln's shopping and see a person who had lost the ability to handle money, you could not have done better than this panel. They were not asked whether she was in pain. They were not qualified to answer that, and nobody offered them the chance. They were asked to audit her. Testimony ran about 3 hours. The jury went out, and came back in about 10 minutes. Now, the form. The jury did not deliver a speech. They were handed a printed county blank, and they filled it in. It recorded that they were satisfied Mary Lincoln was insane and was a fit person to be sent to a state hospital for the insane. It recorded that she was a resident of Cook County. It recorded her age as 56. Under duration of the disease, it recorded unknown. Under cause, it recorded unknown. It recorded that the disease was not hereditary in her case, and that she was not subject to epilepsy. It recorded that she was not a pauper, and it recorded that she did not manifest homicidal or suicidal tendencies. 12 men signed it. She turned to her son and said, "Oh, Robert, to think that my son would ever have done this." A court officer served the warrant on her. The newspaper account says she regarded it with unconcern, and shortly afterwards left the court in the company of Arnold and Swett. She was taken back to the Grand Pacific and kept there overnight with a sheriff's deputy watching her. And within hours of the jury certifying in writing that she showed no suicidal tendency, Mary Lincoln got past everyone. There were people posted outside her door. There was a detective. She walked out anyway and went to the druggist in the hotel and asked for 2 ounces of laudanum and 2 ounces of camphor, and gave as her reason a pain in her shoulder. The clerk stalled her. He told her it would take half an hour. So she took a carriage and went to another drugstore about a block away. But the hotel druggist and the detective following her had already got there, and the clerk had been warned, and she was refused. She went 2 blocks further to a third store, and she was refused there too. Then she came back to the hotel, and the hotel druggist handed her a bottle of burnt sugar and water. She drank it and went to her room. About 20 minutes later, she came back down and asked for more. This time she went behind the counter to watch him fill it. So he took the order down to the cellar, filled it with the same harmless mixture out of her sight, brought it up, and gave it to her. She drank it in the lobby, believing it would kill her, and went back upstairs. 4 stops, 3 refusals, 2 doses of colored water, taken in the certainty that she was dying. The verdict form said she was not suicidal. The ink was not dry. The following morning she was taken west to Batavia, and the doors of Bellevue Place closed behind her. Now, the law that put her there was not an old law. It was not a relic. It was 8 years old. It was called an Act for the Protection of Personal Liberty, and it existed because a woman had fought her own husband to get it written. Her name was Elizabeth Packard. We need to go back. In 1851, the state of Illinois passed a statute governing who could be put into the state asylum and how. The general rule was what you would expect. A person could not be confined without evidence of insanity. There was a procedure, there were safeguards, and then there was a clause. The clause said that married women could be admitted at the request of the husband, on the judgment of the asylum superintendent, and it said this could be done without the evidence of insanity required in other cases. Read that again, slowly, because the law is telling you exactly what it thinks a wife is. Every other adult in Illinois had to be proven insane. A wife had to be handed over. The evidentiary standard that protected everybody else was written out of existence for one category of person, and the category was defined not by symptom or by danger, but by marriage. In 1860, a minister named Theophilus Packard used that clause on his wife. Elizabeth Packard was 43 years old and had 6 children. What she had done was disagree with her husband about religion, in public, in his own congregation, and refused to stop. He signed the paperwork. She was taken to the Illinois State Hospital for the insane at Jacksonville, and she stayed there 3 years. They let her out in 1863, not because anyone decided she was well, but because the hospital had concluded there was nothing they could do for her. Her husband took her home and locked her in a room and nailed the windows shut. A neighbor got word out. In 1864, a writ of habeas corpus brought her before a court in Kankakee, and the question put to that jury was whether Elizabeth Packard was insane. And here is the difference between that courtroom and the one we just left. She had a defense. Witnesses were called for her, neighbors who had watched the house, a physician who had actually talked to her. Her own writings were put in front of the jury so that 12 men could read what she had actually said, rather than hear it characterized by the man who wanted her confined. The jury was out 7 minutes. They found her sane. 7 minutes to free Elizabeth Packard. 11 years later, 10 minutes to commit Mary Lincoln. I am not going to make more of that symmetry than it can bear, but I am not going to pretend I did not notice it either. What Packard did next is the reason her name matters here. She did not go quietly back into private life. She went to the Illinois legislature and she lobbied, and in 1867, the state passed an act for the protection of personal liberty. Over the following decades, she took the same fight into other states, and several of them passed personal liberty laws of their own. The 1867 Illinois Act did 2 things. It killed the Married Women Clause. A wife was now, for this purpose, a person. And it required that nobody could be committed to an asylum without evidence of insanity, a trial by jury, and the right to counsel. I want to be honest with you about the limits of what I can tell you here. I could confirm the Act's title and the page it occupies in the 1867 session laws. I could not get the operative text itself, so I am describing what the statute is understood to have required from legal historians, and not quoting it, and you should hold my description at that grade. But the shape of it is not in doubt, and the shape is the point. Elizabeth Packard built the machine that convicted Mary Lincoln. She built it out of the best intentions anybody has ever had. She built it because she had personally survived the alternative. She looked at a system where a man's signature was enough, and she said, "Put it in front of a jury, in public, with a lawyer, and no family will ever be able to do this quietly again." And she was right. It could no longer be done quietly. It could be done in 3 hours. Now, what did that law actually give Mary Lincoln? It gave her 12 jurors. It gave her a public proceeding, which is why we have any account of it at all. It gave her counsel of record. It gave her a verdict instead of an administrative signature. What it did not give her was time. There is no notice provision that operated here. She was served an hour before, and this was not a Chicago peculiarity or a one-afternoon accident, and I can prove that to you, because in April of 1879, a British psychiatric journal published a survey of how Illinois was running these trials. The Journal of Mental Science observed that in that state, a jury trial seemed to be necessary to send a man to an asylum, however insane he might be. And then it described how the difficulty was being handled. It said the problem of doing this with safety, with expedition, and without even the knowledge of the patient who is being tried, had been cleverly solved by the Americans. I am not editorializing. That is a contemporary medical journal, writing 4 years after Mary Lincoln's trial, describing as a solved engineering problem the practice of trying people for their liberty without telling them it was happening. Cleverly solved. The protection was real. The workaround was routine. So that is the machine. Now we need the woman, because the case against her was not built out of the 19th of May. It was built out of 10 years, and those 10 years were presented to the jury as a pattern of deterioration. They were also, and this is the part the courtroom had no method for hearing, the 10 years in which almost everyone she loved died. We have to go back to 1850. Her second son, Edward Baker Lincoln, called Eddie, died in Springfield on the 1st of February, 1850. He was 3 years and 11 months old. The recorded cause was chronic consumption, which is to say, tuberculosis. He was sick for about 7 weeks before the end. That is the first one. She was 31. The second is the one that changes everything. William Wallace Lincoln, called Willie, was 11 years old, and he was the son everybody in the household agreed was the most like his father. He fell ill in early February of 1862 in the White House. The water supply came from the Potomac, and it was contaminated, and what he had was typhoid fever. He died at 5 o'clock in the afternoon on Thursday the 20th of February, 1862. The funeral was held 4 days later in the East Room. His mother did not attend. She was in bed for 3 weeks. She did not appear in public for months. She never again entered the room where he died. She never again entered the room where he was embalmed. Those were rooms in the house she lived in. For the remaining 3 years in that building, she moved around 2 spaces she would not enter. Her dressmaker and confidant, Elizabeth Keckley, wrote later that Mary Lincoln's grief was inconsolable and that the pale face of her dead boy threw her into convulsions. Keckley is writing 6 years afterwards in a memoir, so grade that accordingly, but she was in the house. And Keckley recorded one more thing, and this sentence has done more damage to Mary Lincoln's posthumous reputation than any other sentence ever written about her. She wrote that the president took his wife to a window and pointed at a building on a hill in the distance and said, "Mother, do you see that large white building on the hill yonder? Try and control your grief, or it will drive you mad, and we may have to send you there." The building was the government hospital for the insane. Now, I have to slow down here, because this is exactly the kind of detail that a documentary uses badly. That line is a memoir line. It is not a document. It appears in a book published in 1868 by a woman who had every reason to remember the scene and no obligation to record it exactly. It has been quoted for 150 years as though Abraham Lincoln prophesied his wife's committal, and it may be word for word true, and it may be the shape a real conversation took in memory. What I can tell you is what it establishes, even at its weakest grade. In 1862, inside her own household, the possibility of Mary Lincoln being sent to an asylum was close enough to the surface that somebody remembered it being said out loud. 13 years before it happened. What she did after Willie died was start attending seances. And here, I have to correct something. The seances are the single most misused fact in her biography. They were used against her in that courtroom in a very specific way, and I want you to be able to see the mechanism. Spiritualism in 1862. America was not a fringe practice. It was a mass movement. Historians studying its rise put participation in the thousands and possibly the millions, and they are careful to say those numbers cannot be verified directly, and the engine driving it was not credulity. It was bereavement. A country in the middle of a war that was killing its sons at a rate nobody had imagined was looking for evidence that the dead continued. There is a second thing about it that matters. Spiritualism was one of the very few public platforms in 19th century America on which women were permitted to speak with authority. So a grieving mother in 1862, attending a séance, was doing an ordinary thing, not a wise thing, necessarily, and not a safe one, as we are about to see, but an ordinary one. She went to a house in Georgetown, belonging to a family named Laurie, who were among the best-known mediums in the capital. She later had mediums brought into the White House, and the evidence suggests as many as 8 sittings took place there. Whether her husband attended, and how often, is genuinely disputed. The most colorful accounts of him doing so come from a memoir published in 1891, 26 years after he died. That is not a grade of evidence I am going to lean on. And then there was Colchester. He called himself Lord Charles Colchester and claimed to be the illegitimate son of an English duke. He held séances for Mary Lincoln at the White House and at the Soldiers' Home cottage. He produced messages from Willie as taps on the walls and scratches in the wainscoting. A journalist named Noah Brooks went to one of these sittings. In the dark, a drum sounded and a banjo played and bells rang, and Brooks got his hands free and grabbed in the direction of the noise and caught hold of a hand holding a bell. Colchester hit him in the head with the drum and cut his forehead open. That account comes from Brooks, and only from Brooks. What happened next is better documented. Colchester wrote to Mary Lincoln demanding a War Department pass to New York, and indicated that if she refused, he might have some unpleasant things to say about her. She had sat in dark rooms with this man and talked about her dead child, and he had worked out what that was worth. Brooks confronted him and threatened him with prison, and he left Washington in the summer of 1863. There is a coda to Colchester that I include because it is documented and because it is almost too much. A room clerk at the National Hotel later described him as an associate of John Wilkes Booth. They drank together. Colchester visited Booth at the hotel in the weeks before the assassination, and in the days before the 14th of April, when somebody urged the president to take more care of himself, Lincoln answered that Colchester had been telling him the same thing. What Colchester knew, if anything, is unknown. The record is mute. I am not going to build anything on it. There was one more man, and this one left a physical object behind. William Mumler had been a jewelry engraver in Boston before he discovered that if you handled a photographic plate a certain way, the customer got a portrait of themselves with a dead relative standing behind them. He called himself a spirit photographer, and he worked the trade for about 20 years. He was prosecuted for fraud in New York in 1869. Phineas Barnum testified against him and hired a photographer to produce a demonstration fake for the court. Consider what that says about American public life at the time. The country's most famous showman was the prosecution's expert witness on humbug. Mumler was acquitted. Nobody could prove the method. By his own account, in February of 1872, a woman in mourning came to his studio in Boston and sat for a portrait. The date comes from a letter he wrote to a Boston newspaper, and so does the claim that she sat under a false name, so both details reach us from the man selling the picture. The photograph exists. You have almost certainly seen it. She is seated, hands folded in her lap, in black. Standing behind her, translucent, is her husband, with his hands resting on her shoulders. That image is now held in a Lincoln research collection in Fort Wayne, Indiana. It is one of the most reproduced photographs of her in existence. It is a fake, made by a man who charged her for it. She kept it. I am not going to mock her for that. Every generation has an industry that sells the bereaved a picture of what they have lost. Ours has better technology and worse taste. But hold on to the mechanism, because the mechanism is what convicted her. A woman goes to seances because her son is dead. A fraud extracts what she says there. 13 years later, a physician stands in a courtroom and reports that she spoke of spirits and of raps on a table, and the jury hears a symptom. She was not tried for attending seances. She was tried for the vocabulary they had given her. One more thing from the war years, and it is physical. On the 2nd of July, 1863, which was the second day at Gettysburg, Mary Lincoln was riding from the soldiers' home back to the White House when the driver's seat came off the presidential carriage. The driver was thrown. The horses bolted. She went out of the vehicle and struck her head, and the wound at the back of her skull, apparently opened on a sharp stone, was stitched by an army surgeon. A week later, it was infected and had to be lanced. Her migraines, which she had suffered from for years, became more frequent after that day. And Robert Lincoln said, later, that his mother never fully recovered from that head injury. I want you to notice who that testimony comes from. The man who committed her believed she had a physical brain injury. Nobody put that in front of the jury either. Then the 14th of April, 1865. They were in boxes 7 and 8 at Ford's Theater, the partition between them removed to make one space. She was sitting beside her husband. She was holding on to him, and she was laughing. And moments before the shot, she said something to him about it. She asked what Miss Harris would think of her hanging on to him so. He said Miss Harris would not think anything about it. That is the last exchange of their marriage that anybody recorded. Then a man came through the door behind them and fired once into the back of Abraham Lincoln's head from a distance of a few feet. Mary Lincoln was close enough to be touching him. She was the nearest witness in the world to it. She screamed. The house turned. She was found holding his head up as he slumped in the chair. They carried him across the street to a boarding house and put him diagonally on a bed too small for him, and she was kept in the front parlor and allowed in from time to time. More than 40 people passed through that house during the night. A resident of the house recorded her arriving and crying out, "Where is my husband? Where is my husband?" wringing her hands. The Assistant Secretary of the Treasury found her alone in the parlor, still wearing her bonnet and her gloves, saying one sentence over and over. She was asking why he did not shoot her too. She was asking it 3 times in a row, and the man who heard it wrote it down 3 times. She stayed in the White House for 5 weeks afterwards, mostly in a darkened room, unable to travel or to organize the removal of her belongings. And the country began to talk. There was a government to hand over and a body to bury and a war to finish. And the president's widow was upstairs and would not come down and would not leave. Newspapers noticed. The story that circulated afterwards, that she had looted the house on her way out, has never been substantiated in the form it was told, and it attached itself to her permanently. This is the moment the public version of Mary Lincoln is fixed, not grieving, excessive, not stricken, inconvenient. She had been in the room. She had his blood on her dress, and the complaint that formed against her within weeks was that she was taking too long about it. That is where the 10 years start. Now the money, because the money is what the merchants testified about, and the money is where the case against her was actually built. Abraham Lincoln died without a will. His estate was worth about $83,000 at his death. Judge David Davis administered it, and under his management, it grew to about $111,000 by the time it was distributed at the end of 1868. 3 heirs, 1/3 each, $36,991.54 apiece. Davis, to his credit, refused the 6% administrator's fee he was entitled to, which came to more than $6,000. 3.5 years. Congress voted her the balance of her husband's presidential salary, $25,000 gross, in December of 1865. After deductions, the warrant came to about $22,000, and in the years while the estate was tied up, her stated annual income was $1,700. Against store debts that she had run up in the White House and that she had been concealing from her husband while he was alive. She told Keckley in 1864 that she owed about $27,000, mostly at a single New York store, and that if her husband knew the extent of it, the knowledge would drive him mad. Keckley put the figure at his death at $70,000. Modern estimates run as low as $38,000. Nobody actually knows. The lower figure is Mary Lincoln's own account of her debts. The higher one is Keckley's estimate of where they stood at the assassination. The gap between them tells you how solid the bookkeeping on this has ever been. So, $1,700 a year. Debts somewhere between $38,000 and $70,000, and an inheritance she could not touch for 3 years and did not know when she would get. In September of 1867, she went to New York under the name Mrs. Clark and tried to sell her clothes. The wardrobe and jewelry came to something over $24,000 by her own valuation, and she wrote that she was willing to take 16. She ended up with a firm of brokers on Broadway, and one of the partners recognized her because he found her name engraved inside a ring. And then the scheme changed shape. The brokers proposed showing her letters, the ones in which she described her circumstances, to prominent Republicans, on the theory that they would pay to stop the martyr's widow being publicly exposed as destitute. The politicians refused. The letters went to the New York World on the 3rd of October, 1867. The wardrobe went on public exhibition in the brokers' rooms. Crowds came to look at the dead president's wife's dresses hanging on racks. 3 United States senators are recorded among the visitors. Most of the people who came were not buying. The press reaction split almost exactly along party lines, which tells you what it actually was. The Chicago Tribune, defending the Republicans, still called it a very niggardly piece of business to have given her only 10 months and 20 days of salary. Democratic papers attacked Republican ingratitude. The Brooklyn Eagle, hearing about a proposed $100,000 testimonial that had raised $1, asked where the remaining $99,999 were. By March of 1868, the brokers had sold almost nothing and had charged her $800 in fees. And the Chicago Journal, watching all of this, printed a sentence, "I need you to hold," because it is dated 1867. It said that the most charitable construction Mary Lincoln's friends could put on her strange course was that she is insane. 8 years before the trial, in print, in a Chicago newspaper, the verdict was in circulation before there was a case. And then, the following year, her friend published her letters. Elizabeth Keckley had been born into slavery in Virginia. She bought her own freedom and her son's for $1,200, built a dressmaking business in Washington, and became Mary Lincoln's modiste, her confidant and, in the White House years, something close to the only person she fully trusted. She had gone to New York with her during the wardrobe fiasco and stated her reason plainly. Mary Lincoln was the wife of the man who had done so much for her race, and she could refuse her nothing. In 1868, Keckley published a memoir called Behind the Scenes. In the back of it, as an appendix, were Mary Lincoln's private letters to her. Whether Keckley intended that, or whether her publisher took them and put them in, is still argued by scholars, and I lean toward the reading that she was badly used by the people producing her book. What is not in dispute is the effect. A woman who had already been humiliated in every newspaper in the country opened a book written by her closest friend and found her own handwriting in it. The friendship did not survive it in the form it had taken. Keckley maintained afterwards that the two women went on corresponding, and historians divide on how completely the break went. What is not in dispute is that the closeness was over. And I need you to hear what was in those letters, because it is the single most important thing in this entire case, and almost nobody puts it where it belongs. From Chicago, the 6th of October, 1867, at the height of the scandal, she wrote to Keckley, "I pray for death this morning. Only my darling Tatty prevents my taking my life." 2 days later, "You would not recognize me now. The glass shows me a pale, wretched, haggard face." In November, on the brokers, "Their delay, I fear, has ruined the business. I believe in my heart I am being used as a tool for party purposes." And in January of 1868, again, "I am so miserable I feel like taking my own life. My darling boy, my Tatty alone, I fully believe, prevents the deed. Now put that against the form." On the 19th of May, 1875, 12 men in Chicago certified in writing that Mary Lincoln did not manifest suicidal tendencies. She had written twice, in letters that had been printed in a book 7 years earlier and sold in that city, that the only thing keeping her alive was her son, Tad. Tad had been dead for 4 years. Nobody raised it. Not the petitioner, who was arguing she was a danger to herself and would have had the strongest documentary evidence in the case sitting on a shelf. Not her counsel, who might have used it to argue that this was long grief rather than sudden madness. Not the physicians. Not the jury. The most published woman in America had told the country in print that she wanted to die, and a court that spent an afternoon deciding whether she was a danger to herself never looked at it. That is not a jury being fooled. That is a proceeding in which nobody was assigned to look. Meanwhile, she was petitioning Congress for a pension from Frankfurt, where she had gone partly to live more cheaply. Her petition survives. It was found in an attic in the Capitol in 1910. She wrote that she was the widow of a president of the United States whose life was sacrificed in his country's service. The House Pensions Committee initially recommended denial on the grounds that the existing law did not cover her. She fought for 5 years. The bill passed on the 14th of July, 1870, on a party line vote. $3,000 a year. For scale, citizens of New York gave Ulysses Grant $100,000 while he was alive and in good health. When President Garfield was assassinated 11 years after Mary Lincoln's pension fight, the public subscription for his widow reached something over $350,000. Mary Lincoln fought 5 years for $3,000 a year. She wrote to a friend from Frankfurt that she was living in second-class boarding houses, and that the horror and the humiliation of it surpassed anything he could imagine. That is the woman the merchants were describing when they told a Chicago jury that she bought too many gloves. And then one more death. Tad Lincoln was 18. He had been in Europe with his mother and had come home in May of 1871, and he got sick almost immediately. The Chicago Tribune called it dropsy of the chest. What that probably meant was fluid compressing the lungs and crowding the heart, and the underlying cause has never been firmly established. He died on the 15th of July, 1871, in a hotel in Chicago. She was too distraught to go to the burial in Springfield. She had now buried 3 sons and been sitting beside her husband when he was shot. Of the 5 people in her family, she and Robert were what remained. And 1 week after Tad died, Robert Lincoln left for the Rocky Mountains. I am not going to characterize that. I am going to put the date next to the date and let you do what you want with it. 4 years later, in the winter of 1874 and 75, she was in Jacksonville, Florida, keeping the shades drawn and taking chloral hydrate to sleep. In March, she became convinced that Robert was dying. She telegraphed his physician. "My belief is my son is ill. Telegraph." Then she telegraphed Robert himself and told him to live until she got there. She got on a train and came north, and on that train she told people someone had tried to poison her and that a wandering Jew had stolen her pocketbook. She arrived in Chicago on the 15th of March to find her son in perfect health. She refused to stay in his house. He took rooms at the Grand Pacific adjoining hers and hired a woman to sleep in her room. On the 1st of April, there was the incident in the elevator. In late April, he hired detectives to follow her when she went shopping. On the 15th of May, 6 physicians met privately and agreed, on his account of it, that she was insane. On the 18th of May, the detectives watched her carrying the bonds. On the 19th of May, Leonard Swett knocked on her door at 1 o'clock. So that is the case, laid out at its strongest, and I want to be fair to it. A woman with a documented head injury, a documented history of migraines and neuralgia, a documented 10-year run of catastrophic bereavement, taking a sedative to get through the night, telling people she was being poisoned, carrying her fortune on her body, buying curtains for windows she did not have. If you are Robert Lincoln in April of 1875, you are not looking at nothing. But that is not the question the jury was asked. The jury was not asked whether his mother was struggling. It was asked whether she was insane and whether she was fit to be sent to a state hospital. It answered both in about 10 minutes. The evidence was 17 people, 5 of them doctors, and only one of those 5 had ever examined her, which raises the thing that nobody in that courtroom had any way to test. What happens if you take a woman the law has just called insane and put her somewhere and watch her every day and write down what she actually does? Because somebody did exactly that. For 113 days, Bellevue Place stood on South Jefferson Street in Batavia, Illinois, about 40 miles west of Chicago, on 16 acres. The building had not been built as an asylum. It went up in 1853 and 1854 out of limestone quarried locally in the Greek Revival style at a cost of about $20,000, and it was originally a private academy called the Batavia Institute. Dr. Richard Patterson and his partners bought the property in 1867 and reopened it as a sanitarium. It took women only. Wings with mansard roofs had been added 4 years earlier, bringing capacity to something like 25 or 30 patients, and during Mary Lincoln's residence, there were about 20 women in the house. There was a greenhouse nearly finished that season. There were orchards, and a vegetable garden, and a laundry, and walks laid out among flower beds and evergreens and shade trees, and hammocks on the lawn. The barn held horses and pigs and cows, a carriage, 2 buggies and 2 sleighs. Admission was restricted, in the institution's own advertising language, to a select class of lady patients of quiet, unexceptionable habits. Her rooms cost $10 a day. Now, before we go inside, I want you to look at that sentence again next to the verdict form, because the 2 documents do not match. The jury found that Mary Lincoln was a fit person to be sent to a state hospital for the insane. That is what the form says. That is the finding 12 men signed. She was never sent to a state hospital. She was taken to a private establishment in a county 40 miles away. It was run by one of the physicians who had signed a certificate against her the day before the trial without examining her. Her son paid $10 a day for it. I am not going to tell you that was worse for her. In every measurable way, it was better. The state hospital at Jacksonville, where Elizabeth Packard had spent 3 years, was not a place anybody would choose. What I am telling you is that the finding the jury made and the thing that was done to her were 2 different things, and nobody went back to court about it. The form was the legal authority. The form was not the plan. The plan had been arranged before the trial by the man who owned the destination. Sit with that for a moment. Patterson practiced what the 19th century called moral treatment, and he described his own method in a sentence worth hearing in his words, because he was not a monster and the record should say so. He called it the modern management of mental disease by rest, diet, baths, fresh air, occupation, diversion, change of scene, no more medicine than absolutely necessary, and the least restraint possible. That was not marketing. It was, by the standards of 1875, humane and progressive medicine. Mary Lincoln was given a 2-room suite on the 2nd floor, next to the quarters of the Patterson family. The windows were barred. The doors leading to the outer world were never locked during the daytime. At night, her bedroom was locked, and an attendant who slept in the adjoining room held the key. She had a nurse assigned to her alone. She ate either downstairs with the Pattersons or by herself in her rooms. She had a horse and carriage at her disposal. She received no physical restraint of any kind. She was given no drugs. Other women in that house were being managed with morphia, with cannabis, with eggnog and whiskey. The staff monitored patients' weight and their eating and their menstrual cycles. Mary Lincoln got none of that. She got a carriage, an unlocked door in daylight, and a nurse. Patterson kept progress reports, and this is the closest thing that exists to a controlled observation of Mary Lincoln. Made daily, made by a physician who had already committed himself in writing to the opinion that she was insane, and who therefore had no incentive to record anything that undermined him. Here is what he wrote. On the 20th of May, the day she arrived, he recorded that the case was one of mental impairment which probably dated back to the murder of President Lincoln. For the first 5 days, he described her as cheerful, contented, and talkable. On the 22nd of May, he wrote that she seemed cheerful and was apparently contented. Then it turns. By the end of May, she had become, in his phrasing, very melancholy. Through June, she kept her room closely and refused to ride out, and spent a good part of the time in bed, and on some days did not go outdoors at all. On the 14th of June, he noted that she complained of neuralgia and gave that as her reason for not going out. On the 2nd of July, he wrote something oddly specific and oddly sad. He recorded that she habitually made an appointment to ride in the morning, and that when the time came, she put it off until night. On the 5th of July, a fit of crying. He noted that her conversation was of the most commonplace character, with much repetition. He noted great capriciousness about her food and her washing. He recorded that she would order cornbread, leave it untouched, and ask for rolls instead. And on the 16th of August, he wrote that Mrs. Lincoln was frequently untruthful in her statements and exceedingly deceitful. Now, there are two ways to read that record, and both are held by serious historians. I am going to give you both. The honest version of this story does not let you have only one. The first reading belongs to Jean Baker, who wrote the biography that reframed Mary Lincoln for a generation. Baker looks at the daily entries and points out what is in them. A woman visiting with the superintendent's wife, a woman taking carriage rides, talking to the Pattersons' daughter, sitting on the front stairs, writing letters. Baker's line is that at Batavia, Mary Lincoln did the thing she had been convicted of failing to do. She lived a normal life. The second reading belongs to Jason Emerson, who has done more archival work on this case than anyone alive. Emerson looks at the same entries and sees the arc. Cheerful for 5 days, then melancholy, then in bed, then refusing to leave the room, then weeping. He reads a woman who is ill, in a humane setting, whose illness the record is actually capturing in real time. Both of those readings are available in the same notebook. That is not a failure of the historians. That is what the document is like. But there is one entry whose position in the calendar nobody disputes, and I want to put it in front of you without telling you what to do with it. The entry calling her untruthful and exceedingly deceitful is dated the 16th of August. 9 days earlier, on the 7th of August, a newspaperman had been smuggled into her room and had spent 2 hours with her. Let me tell you how that happened. Sometime in the summer of 1875, Mary Lincoln got a letter out of Bellevue Place. There were 2 channels, and they were probably both used. On the 28th of July, during a visit from Robert, she asked her son to post a letter for her to General John Farnsworth, who had been a congressman from that part of Illinois. Robert posted it. Farnsworth came to Batavia the next day and told Patterson that Mary Lincoln should be released, and separately passed whatever control the institution kept over her correspondence. Letters went to the editor of the Chicago Times and to a couple named Bradwell. Her note to James Bradwell survives, and it is one line. She asked him to come out just as soon as he received it. Now I need to tell you who Myra Bradwell was, and I need to be careful, because the way this fact usually gets stated is wrong in a way that makes the story smaller. Myra Colby Bradwell was born in Manchester, Vermont, in 1831. In 1868, she founded the Chicago Legal News. She was its editor and its business manager. It became the official medium for publishing court records in the state of Illinois and the most widely circulated legal newspaper in the country. In 1869, she sat the Illinois bar examination and passed it. A federal judge pronounced her qualified. The Illinois Supreme Court refused to admit her. Their first ground was not that she was a woman. Their first ground was coverture, the doctrine that a married woman had no separate legal existence from her husband. The court reasoned that as a married woman, she would not be bound by her own contracts, and therefore could not be bound by the contract between an attorney and a client. Sit with the mechanism there. Not, we will not let you. You do not exist separately enough to make a promise. She appealed to the Supreme Court of the United States. Bradwell against Illinois was argued in January of 1873 and decided that April, and she lost 8-1. The majority held that the right to practice law was not a privilege or immunity of national citizenship. That was the narrow legal holding. But Justice Joseph Bradley wrote separately, joined by 2 others, and Bradley did not bother with the narrow ground. He wrote that woman's paramount destiny and mission was to fulfill the noble and benign offices of wife and mother. That is a justice of the Supreme Court in 1873, holding that a woman cannot be a lawyer because being a wife is what she is for. The one dissent was Chief Justice Salmon Chase, who was too ill to write an opinion. He was dead 3 weeks later. Illinois had actually passed a statute the year before, saying that no person should be barred from any occupation on account of sex. Myra Bradwell never reapplied. The Illinois Supreme Court finally admitted her on its own motion in 1890, backdating it to 1869. The United States Supreme Court bar admitted her in 1892. She died of cancer 2 years after that. So here is the precision point, and it is the whole reason I have taken you through this. In 1875, when Mary Lincoln got a note out of an asylum, the person who received it was not a lawyer. She was the best legally trained mind in Chicago, who had been told by 2 Supreme Courts that she could not be one. Now watch what she did with that. Patterson refused her entry at first. She got in later. By one account, when she spoke to Patterson in July, she told him there was no doubt Mary Lincoln was insane and had been for some time. What propriety required, she said, was simply that she be moved to her sister's house in Springfield for tender, loving care. By another account, asked the same question by a reporter from the Chicago Times, she answered that Mary Lincoln was no more insane than she was. Those 2 statements cannot both be her honest opinion. They can very easily both be things she said. I will give you the argument on each side. If you already think Mary Lincoln was ill, the July statement is Bradwell's real view, and the public line was campaigning. If you think Mary Lincoln was railroaded, the July statement reaches us only through the asylum's own account of a meeting, written by the people she was fighting. And it is exactly what a lawyer says to a man she needs to keep talking to her. I do not know which it is. I do know which one she acted on. She wrote to Mary Lincoln almost daily. She wrote to Robert. She wrote to the man who ran the institution. She wrote to Elizabeth Edwards, Mary's sister in Springfield. Mary felt her incarceration most terribly, she said, and desired to get out from behind the grates. She could not feel it was necessary to keep her thus restrained. Her husband wrote to John Todd Stewart. Her husband, who was a sitting member of the Illinois General Assembly and a former Cook County judge, threatened the sanitarium with a writ of habeas corpus. That is the same instrument that had pulled Elizabeth Packard into a Kankakee courtroom 11 years before, and the Bradwells knew exactly what it was worth. And, on the 7th of August, Myra Bradwell brought Frank Wilkie, an editorial writer for the Chicago Times, into Bellevue Place, and the 3 of them sat in Mary Lincoln's room for 2 hours. Wilkie left, saying he had seen not a sign of weakness or any abnormal manifestation of mind, and described her physical health as superb. His article ran on the 24th of August under a headline that told Chicago what it was about to read. Mrs. Lincoln. Her physicians pronounce her entirely sane. His conclusion was carefully worded, and it is worth hearing exactly. He wrote that whatever condition of mind Mrs. Lincoln may have been in previously, she is unquestionably compos mentis now. The next day, the Chicago Post and Mail ran an interview with Judge James Bradwell, attacking Patterson's competence and describing Mary Lincoln's virtual imprisonment. Articles were placed in other papers. Now go back to the calendar. Wilkie is in her room on the 7th of August. Robert visits the asylum on the 13th of August and calls Myra Bradwell a pest and a nuisance, and calls the introduction of the reporter an outrage. Patterson writes that Mary Lincoln is frequently untruthful and exceedingly deceitful on the 16th of August. The article runs on the 24th. I want to be careful about what I am claiming there. Patterson had been recording capriciousness and repetition for weeks before Wilkie ever walked in, so the deterioration in his notes is not invented on the 16th of August, but the specific charge changes on that date. Up to then, he is describing a patient. On the 16th, he starts describing a liar. A physician's opinion of a patient's honesty is not a clinical measurement. It is a relationship. 9 days after she went around him to a newspaper, the relationship broke. We do have her own voice from inside that house, because some of the letters she smuggled out survive. On the 2nd of August, 1875, she wrote to the Bradwells, "It does not appear that God is good to have placed me here. I endeavor to read my Bible and offer up my petitions 3 times a day, but my afflicted heart fails me." I want you to look at the construction of those 3 sentences, because they are the best available evidence of what her mind was doing in that room. The first is a complaint against God, which is an ordinary thing for a religious person in extremity to say, and has been in the literature since the book of Job. The second is an account of a maintained daily discipline 3 times a day, which she is reporting because she knows it is the answer to the first. And the third concedes that the discipline is not working. That is a structured argument. Premise, mitigation, honest concession. She wrote it in an asylum, under observation, on the 75th day of a confinement she had no reason to think would end. Around the same time, she wrote something about her son that is harder to read. She wrote that she rather thought he would prefer her remaining there. Not a delusion of persecution, not an accusation of theft, a quiet, accurate assessment of what was convenient for somebody else. Now, in fairness to Robert Lincoln, because this channel does not get to only make one case, there is a version of this story where the son is stealing his mother's money, and the numbers do not support it. Robert served as conservator of her estate for 1 year. Over that period, the estate generated more than $4,000 in interest. He took no compensation for the work, although the law entitled him to it. During the months she was in Springfield, he sent Elizabeth Edwards 15 checks, totaling $4,599.28. He did not take $1. He grew it. Which means that if you want to indict Robert Lincoln, you cannot indict him for greed. You have to indict him for something much more ordinary and much harder to prove. He was certain. He had the resources to act on certainty, and the law let him do it in 1 afternoon. Elizabeth Edwards had not been consulted about any of it. She wrote to Myra Bradwell that had she been consulted, she would have remonstrated earnestly against the step taken. And then, on the 15th of August, she wrote the sentence that ended the confinement. She wrote that it may be that a refusal to yield to her wishes at this crisis will greatly increase her disorder. Look at what that sentence does. It does not say her sister is sane. It concedes the disorder. It simply points out that keeping her there might make it worse. It is an argument built entirely inside the other side's premises, and it is unanswerable. I would be very surprised if a woman who had spent 4 years litigating her way to the Supreme Court of the United States had nothing to do with the shape of it. On the 10th of September, 1875, Mary Lincoln left Batavia for Springfield, escorted by her son. Patterson opposed it. 113 days. And I need to be exact about what had and had not just happened, because almost every retelling gets this wrong. She was not discharged. She was not found sane. No court had reviewed anything. The judgment of the 19th of May was still in force. Robert Lincoln was still conservator of her estate, and she did not control a dollar of her own money. What had happened was that the custody of a legally insane woman had been transferred from an institution to her sister's house. Neely and McMurtry, the two historians who first published Robert's private file on all of this, gave that period a one-word title. They called it The Experiment, because everybody involved understood exactly what it was. A test with a subject who did not know she was being tested, and no agreed criteria, and no fixed end date, and one hard rule. If it failed, she went back. The house in Springfield belonged to Ninian and Elizabeth Edwards, and it stood on 2nd Street, on the rise south of the state capitol that the town called Aristocracy Hill. Mary Todd had been living in that house in 1842 when she married Abraham Lincoln, and the ceremony had taken place in its front parlor. Elizabeth was her older sister. Ninian was the son of a governor. This was the household she had come out of. She was returned to it at 56 years old, as a legally insane woman in the custody of relatives. 5 days after she arrived, Elizabeth Edwards wrote to Robert. She told him that a number of their friends had called and were delighted to see his mother looking so well, and that she seemed to heartily enjoy herself. Now hold that letter against the situation it describes. Mary Lincoln was, at that moment, a person to whom the state of Illinois had assigned a legal status. She could not sign a contract that would bind anybody. She could not draw on her own accounts. She could not sell a bond or open one of her own trunks without her son's authority as conservator. Every dollar she spent came to her sister as a check from Chicago, and she was going to dinner and receiving callers and being told she looked well. That is what the experiment actually was. Not a hospital and not a home, a form of house arrest with visitors. She spent 9 months in it. We know a great deal about what she was thinking during those 9 months, and almost all of it comes from her letters, and the thing that grows across them is not confusion. It is a very clear and very cold anger, and it is aimed in exactly one direction. She had already written, from Bellevue, that if she had used excited words about her son, she asked God to forgive her and asked the Bradwells to forget it. That was August. That was a woman still trying to keep a door open. By the time she was in Springfield, the door was shut. She wrote that she rather thought he would prefer her remaining where she had been, and she began, methodically, to work the only problem that could actually be solved. Because here is the position she was in, and I want to lay it out the way a lawyer would, since a lawyer almost certainly did. The finding against her had 2 halves. She was insane, and she was unfit to manage her estate. The first half was about her. The second half was about her money. And in Illinois, the second half could only be undone by a formula. The statute required a jury to find that a person had been restored to reason before property could be handed back. So she could not simply be well. She could not simply be at liberty. She could not be quietly forgiven and left alone in her sister's house for the rest of her life, which is very likely what Robert expected and possibly what he wanted. To get her bonds back, she needed a jury. To get a jury, she needed a petitioner, because she could not file anything herself. The law that had declared her incompetent had also taken away her standing to say so. And to get a petition that would not turn into a fight, she needed the man who had brought the first one not to appear. That is a problem with 3 moving parts, and only one of them was hers. Ninian Edwards became the petitioner, her brother-in-law, the man in whose parlor she had been married, who had watched all of it, and who had never been asked before any of it happened. And through the winter and spring of 1876, the pressure moved to Robert. He was, by then, in a genuinely bad position, and it is worth understanding it clearly, because it explains the ending. His mother was living openly in Springfield and receiving callers who were delighted to see her looking well. A Chicago newspaper had already printed that she was sane. A judge and a legal publisher were writing letters about her to anyone who mattered. His own aunt had told him she would have objected to the whole thing if anyone had asked her. If he contested a restoration petition, he would have to prove his mother insane a second time, in public, in front of the same city, against witnesses who this time would actually be called. He had won the first case because nobody defended it. There was no version of the second one where nobody defended it. So he agreed not to appear. And that consent is the single most important thing to understand about what happened next, because it changes what the second verdict is worth. I am going to say this now rather than after, because I do not want to hand you a triumph and then take it back. What happened in June of 1876 was not a court examining the evidence and reaching the opposite conclusion. Nobody re-examined anything. Nobody called the 17 witnesses back. Nobody asked Dr. Danforth about the wires or the merchants about the curtains. The first trial was uncontested and produced a finding of insanity. The second trial was uncontested and produced a finding of reason. The same court, the same judge, the same absence of an argument. That is not a system correcting an error. That is a system doing what it is told, twice, by whoever happens to be standing in front of it, and getting opposite answers because it was told opposite things. Which means the second verdict cannot exonerate her. It can only convict the process. On the 15th of June, 1876, the County Court of Cook County heard the matter of Mary Lincoln for the second time. Same court, same judge. 13 months. Ninian Edwards brought the petition and testified that his sister-in-law was a proper person to take charge of her own affairs. Robert Lincoln did not appear. He was recorded as offering no objection. The hearing occupied only a few minutes. The jury found that the said Mary Lincoln is restored to reason and is capable to manage and control her estate. That is the whole thing. That is what 13 months, an asylum, 113 days of daily medical observation, a suicide attempt, a newspaper campaign, and a Supreme Court litigant produced. One sentence, on a form, in a few minutes, in a room her son did not enter. Now I want to take that sentence apart, because there is a word in it doing more work than anyone intended. Restored. That is not a description. It is a statutory formula. Illinois law required those words, or words to that effect, before property could be handed back to someone a court had taken it from. So the jury was not offering a medical opinion when they used it. They were completing a required form of words, the way you complete a form of words when you sign a deed. But look at what the formula assumes. Restored means it was taken away and has now been given back. Not that it was never gone. Not that the court was wrong in 1875. The word is constructed so that both verdicts can be true at once, and it is constructed that way on purpose, because a legal system cannot easily say, "I was mistaken about a human being." It can say she has recovered. That is a far more comfortable sentence, and it costs nothing, and it leaves the first judgment standing. So the state of Illinois never withdrew what it said about Mary Lincoln in May of 1875. It said she got better. She, of course, did not accept that framing for a single day. The property came back. Robert returned to his mother something in the region of $73,000, of which about $60,000 was in bonds. The figures in the sources do not perfectly reconcile, and I am giving you the more conservative one. It went into the hands of a Springfield banker named Jacob Bunn, who had been a friend of her husband's. 4 days later, she wrote to her son. The full text of that letter is in print. I am going to read you only the parts I can verify, word for word. This is the most quoted letter she ever wrote, and it has been improved by retelling. It opens without a greeting of any warmth. She writes, "Do not fail to send me, without the least delay, all my paintings, Moses in the bulrushes included, also the fruit picture which hung in your dining room. Not my paintings, all my paintings." And then she itemizes. She is telling him she knows what is on his walls. Further down, "I am now in constant receipt of letters from my friends denouncing you in the bitterest terms." She asks for her books back, Whittier, Pope, Agnes Strickland's Queens of England. And then she closes, "Send me all that I have written for. You have tried your game of robbery long enough." Read that last clause again, slowly, because of what it tells you about how she understood the previous 13 months. Not, "You were wrong about me." Not, "You humiliated me." Robbery. In her account of what happened, the trial was not a mistaken diagnosis. It was a method, and you have to hold two things about that sentence at the same time, and they pull in opposite directions. The first is that she had a case. Her money had in fact been taken. A court had in fact given it to her son. The bonds she had been carrying on her body had in fact been removed from her the day she was committed. The second is that Robert had grown the estate and taken nothing, and that the belief that people were trying to steal her money was, in 1875, one of the specific things she had been committed for. Which is the trap this case never gets out of. The most reasonable thing a person could feel in her position was also the exact symptom she had been convicted of. She wrote to Myra Bradwell, too, within days, and that letter was harsher than the one to her son. Roughly 700 words. She accused Robert of bringing false charges against her in order to take her money. She said his conduct would keep him from approaching his Father in heaven. She encouraged publicity against him, and she wrote that her hair had turned white. She did not speak to her son for about 5 years. On the 1st of October, 1876, 3.5 months after the second verdict, Mary Lincoln sailed from New York on the steamship Labrador with 48 passengers aboard, bound for Le Havre. She settled in Pau, in the French Pyrenees, first at the Grand Hotel and then at the Henri IV. She stayed 4 years. She traveled to Rome and Naples and Sorrento and Vichy. She kept almost no company and did not attach herself to French society. Her own summary of it: "I live very much alone." 10 of her letters from those years were recovered in 2005, and the historian who found them, who is not remotely sympathetic to the idea that she was railroaded, describes them as calm, rational, and coherent. In one of them, she explains what Europe was for. She wrote that she was allowed tranquility there and was not harassed by a demon. The demon was her son. At one point during those years, former President Ulysses Grant and his wife came through Paul on their world tour. They did not call on her. Meanwhile, the body was going. I am going to give you her own measurements, in her own letters, because she kept track, and because nobody has ever accused her of understating her sufferings, and she still turns out to be describing something real. October of 1879. She writes that she is now just the weight she was when they went to Washington in 1861. January of 1880, she writes that she has run down to 100 pounds, exactly. June of 1880, she is trying to manage her own belongings on a fourth floor, with, in her phrase, almost a broken back. She takes a servant's arm, and on attempting to descend, her left side gives way, and the woman has to call the concierge to lift her down. Boils over her whole body, pain that the waters at Vichy did nothing for. Her sight failing. Somewhere in this period there was a fall, and the fall became the official explanation for everything that followed, and I want to show you how it was built, because it is a small masterpiece of how history gets made. The only source for it is Dr. Louis Sayre, a New York orthopedic surgeon. In October of 1880, he told it one way. She was injured while arranging a picture on the wall of her parlor. The chair she was standing on broke, and she was thrown violently backward against the corner of a table. In November of 1881, he told it a different way. It was December of 1879. She mounted a stepladder. It broke under her. She fell on the middle of her back, across the edge of a sofa. Different year, different furniture, different mechanism. And in between those two tellings, Dr. Sayre had become the physician certifying Mary Lincoln's disability for an increase in her federal pension. Two doctors, who re-examined all of this in 1999, Norbert Hirschhorn and Robert Feldman, reject the story on physical grounds. She weighed 100 pounds, and things do not generally break under a 100-pound woman. And a person who falls straight down does not land several feet away across a piece of furniture. Their conclusion reverses the causation entirely. The fall did not cause the ataxia. The ataxia caused the fall. She had been losing control of her legs for years. The version where a stepladder breaks is a story that explains a symptom as an accident, and it is a story that helps with a pension application. She came home in 1880. She boarded the steamer L'Amérique at Le Havre on the 16th of October and reached New York on the 27th. And here I have to deal with the most famous anecdote attached to her name, because it is repeated everywhere and it is half true in a very specific way. Sarah Bernhardt was on that ship. That part is not a legend, and it is independently corroborated. Bernhardt's company left Le Havre for America in mid-October of 1880 and arrived in New York on the 27th, aboard L'Amérique. Two entirely unrelated sources put both women on the same crossing, arriving the same day. What Bernhardt wrote in her memoir decades later is this. During a storm, she saw a woman in mourning about to be swept down a companionway and caught her by the leg. And when she learned who the woman was, she reflected that she had done this unhappy person the one service she did not want. She had saved her from death. There is no other witness, no passenger account, no newspaper report, no letter from Mary Lincoln. And the English renderings of Bernhardt's lines that circulate do not even match each other because they come through different translations. So the honest formulation is this: they were on the same ship. Bernhardt said she caught her. Only Bernhardt ever said it. I am not going to put quotation marks around a line I cannot verify in order to give this story a better scene. She went back to her sister's house in Springfield, into the same rooms she had left. She told Elizabeth she could not trust herself any longer away from them all. She was too ill and feeble in health. She had about 20 months left. Her physician in those months, Dr. Thomas Dresser, wrote about her afterwards, and he described a habit he considered the most singular of all her peculiarities. During the last year or so of her life, she shut herself in a perfectly dark room, and for light used a small candle, even when the sun was shining bright out of doors. Jason Emerson's description of the same period. She sat in the dark with a single candle, packing and unpacking 64 trunks of clothing. She slept on one side of the bed and left the other side alone. That is the image that has come down to us, the mad widow in the dark room with the trunks. Now I want to give you one small piece of evidence that has been sitting in the record the whole time. In 1872, a nurse who attended Mary Lincoln recalled something. She thought gas was an invention of the devil and would have nothing but candles in her room. At other times, she insisted the shades be drawn and the room kept perfectly dark. 1872. 3 years before the trial. 8 years before Springfield. The behavior that reads as the final decay of a broken mind was already fully present when she was living an ordinary life in an ordinary hotel. It was there in Florida too, in the winter before her trial, when she kept the shades down. So either she was mad for a decade in exactly the same way, or the dark room was not a symptom of madness. On the 1st of January, 1882, 4 physicians examined her formally in connection with her pension: Sayre, Meredith Clymer, Dr. Knapp of New York, William Pancoast of Philadelphia. Their letter records chronic inflammation of the spinal cord, chronic disease of the kidneys, and commencing cataract in both eyes. It records considerable loss of power in both lower extremities. It records that she was quite helpless and unable to walk with safety without an attendant. And it records one finding in particular. Connected with the spinal disease, they wrote, and one of its evidences, is the reflex paralysis of the iris of the eye and the reduction of the sight to 1/10 the natural standard. Paralysis of the iris. The iris is the muscle that closes your pupil against light. If it does not respond, light hurts. Permanently, in every room, at every hour, for the rest of your life. That is what Hirschhorn and Feldman identify in their 1999 reappraisal as an Argyll-Robertson pupil, a pupil that will not constrict to light. It is a classic sign of tabes dorsalis, the degeneration of the nerve columns at the back of the spinal cord. It is also the physiological explanation for the candle, the drawn shades, and the aversion to gaslight going back, at least, to 1872. Tabes dorsalis has another feature, and this is where their argument becomes something more than a footnote. It produces what 19th century neurology called lightning pains, sudden, savage, boring sensations in the face and the limbs and behind the eyes. Patients describe them in the only language they have, and the language they reach for is almost always mechanical. Something is drilling, something is pulling, something is being taken out. Go back to Dr. Danforth on the witness stand on the 19th of May, 1875. Someone was at work at her head. Something was removing the bones from her face and pulling wires out of her eyes, and she specified the left eye. Someone was taking steel springs out of her head. Hirschhorn and Feldman's sentence on this is the flattest and heaviest in the whole literature. They write that symptoms, imputed as insanity at her trial, clearly had their origin in the organic disease of tabes dorsalis, which would mean something specific about the most damning testimony of that afternoon. The testimony from the one doctor who had actually treated her was a woman with a degenerating spinal cord, accurately describing her own neurological pain. She described it to a physician who did not recognize it, in the only vocabulary a spiritualist century had given her. Now, same breath. I am not going to hand you that as the answer. The discipline that produced it is contested. And I would be doing exactly what the men in that courtroom did if I took one confident medical opinion and treated it as a finding. Retrospective diagnosis is argued from letters and photographs and hearsay, never from a patient, and a serious body of historians rejects the whole enterprise. Other physicians reading the same material have reached different conclusions. One cardiologist, working from more than 600 of her letters and 100 historical sources, argues for vitamin B12 deficiency from pernicious anemia, which would also produce delusions and progressive weakness from a single cause. And Jason Emerson, who knows the documents better than anyone, argues for bipolar disorder and thinks the whole railroading thesis is a modern story imposed on a 19th century woman. His reading of the letters he himself discovered is that they do not show she was railroaded. They show that she believed she was, and that the belief was itself part of the illness. You cannot dismiss that. It is the strongest version of the case against her, and it is made by the person with the best access to the evidence. What you can do is notice what it requires. It requires that the one interpretation which is unfalsifiable, because any protest becomes proof, be preferred to the one that can be checked against a physical sign in an 1882 medical certificate. I do not know which of them is right. I am not a physician, and neither was that jury. Here is what I am certain of. Not one of these possibilities was raised on the 19th of May, 1875, because raising them would have required somebody in that room to be working for her. That medical examination on the 1st of January, 1882, was not done for her treatment. It was done for a bill. Mary Lincoln, at 63, nearly blind and unable to walk, unaided, had traveled to New York in the autumn of 1881 to put herself under a specialist's care, and from there she was lobbying Congress again. She had been getting $3,000 a year since 1870. She wanted more. She wanted the lump sum that widows of other public men had been given as a matter of course. So she assembled 4 physicians and a congressman and went back to the institution that had made her fight 5 years for the first pension. She won. Both houses passed the bill in the last week of January, 1882, and President Chester Arthur signed it on the 2nd of February. $5,000 a year and $15,000 in a single payment. She died 5.5 months later, and there is a genuine dispute in the sources about whether she ever collected the $15,000. I include that because of what it does to the picture of the woman in the dark room with the trunks. That version of her is real. It is also, on the same calendar, a woman who got herself across the country to a New York specialist and ran a successful federal lobbying campaign while going blind. 7 years earlier, a jury had found she could not be trusted to manage her own affairs. And there was one more thing that happened in those last months. In 1881, Robert Lincoln came to Springfield. He brought his daughter Mamie, who was Mary's granddaughter. They had not spoken in about 5 years. We do not know what was said in that house. Nobody wrote it down, or if they did, it has not survived, and I am not going to invent it for you. What we know is that he came, and that he brought the child, and that the silence ended. A little over a year later, she was dead. Now, the documents, because this case has a second half that happened a century after everyone in it was dead. Robert Lincoln kept a file. He kept it for the rest of his life. Legal papers, newspaper clippings, and a bundle of his mother's letters, tied together with a pink ribbon. He is believed to have destroyed the Bradwell correspondence. In 1927, the year after Robert's death, his widow Mary Harlan Lincoln paid $22,500 to the Bradwell's granddaughter for a manuscript built out of those letters. The family believed the letters had been destroyed with it. They had not. The granddaughter had copied them first. The rest surfaced in stages, and the way it surfaced tells you something about how history actually arrives. In the 1970s, at Hildene, Robert Lincoln's house in Manchester, Vermont, a woman named Betty Hickey was helping catalog the papers of the last of the Lincoln descendants. Her husband was the curator of the Illinois State Historical Library. In a closet in Robert Lincoln's bedroom, she found the file with the pink ribbon. It was published in 1986 under the title his own family had used for it, The Insanity File. And in 2005, after a 5-month search, Jason Emerson found the copies the granddaughter had made in the attic of a house belonging to the family of Robert Lincoln's attorney. About 25 letters nobody had read in 80 years. So the record of this case sat for 130 years in the physical custody of the man who brought the petition, and then of his heirs. It came out of a closet and an attic, in pieces, decades apart. It survived because people kept it rather than burned it. Some of it did get burned. We will never know how much. Mary Lincoln collapsed on the 15th of July, 1882. That was the 11th anniversary of the day Tad died. She lapsed into a coma in the early hours of the next morning and never came out of it. She died that evening, the 16th of July, at her sister's house in Springfield. She was 63 years old. There was no autopsy, and there is no surviving death certificate. Her physician determined the cause. The newspapers reported she had been treated for a disease of the eyes and for diabetes. They laid her out in the front parlor. It was the same room in which she had married Abraham Lincoln in November of 1842. The house had been remodeled over the intervening 40 years, and there was already an argument by 1918 about whether the wedding room was still identifiable. So I will give you the version I can stand behind. Same house, almost certainly the same parlor. 40 years, 3 dead sons, 1 murdered husband, 1 asylum, 2 juries, and about 200 feet of ground between the 2 events. The funeral was on the 19th of July at the First Presbyterian Church. The Reverend James Reed took it. The crowd was so large it was uncomfortable, and many people could not get in. Springfield's mayor declared a holiday. Reed's line about her was that all that remains of a princely woman lies before us. She was buried at Oak Ridge, beside the sarcophagus holding the remains of her husband. 2 years later, her estate was settled. Robert Lincoln inherited $84,035. I want to put that number next to the finding of the 19th of May, 1875, and leave it there. In 1875, a jury of 12 Chicago businessmen determined that Mary Lincoln was incapable of managing her estate. The petition put that estate at not exceeding $75,000 and she had built it out of an inheritance of about $37,000 received 7 years earlier. Robert handed back about $73,000 in 1876. She then controlled it for 6 more years, through 4 years abroad, through progressive blindness and progressive paralysis, buying whatever she wanted. She left $84,035. Some of that rise is the pension increase of her final year, and I am not going to hide that. The rest of it is the plain fact that the woman a court had found unfit to manage money did not eat into her principal in the 7 years after they told her she could not be trusted with it. She finished ahead. That is not an argument. That is arithmetic. And arithmetic, unlike testimony, does not need to be examined by a physician first. Robert Lincoln lived another 44 years. He became president of the Pullman Company. He was Secretary of War. He was minister to Britain. He was, by any conventional measure, the most successful of all the presidential children in American history, and he was in the vicinity of 3 presidential assassinations, and he refused the nomination himself more than once. He was asked about his mother. He did not answer. He never published a defense, never gave an interview about 1875, never wrote the account that would have settled it. He kept the file instead, in a closet, with a ribbon around it, for the rest of his life, and did not destroy it. That is a strange thing to do with evidence against yourself. You destroy it, or you use it. He did neither. He kept it where it would be found, by somebody, eventually, and said nothing. His widow paid $22,500 in 1927 to keep the other half of the story out of print. Between them, that is the family's answer. Not a word in public for half a century, and a great deal of money spent making sure nobody else said one either. Everyone else in that courtroom got an ending too, and the endings are worth 2 minutes. Leonard Swett, who came to her hotel room at 1 o'clock and told her officers were waiting downstairs with handcuffs, wrote his own account of that conversation almost immediately. He did not hide any of it. He recorded her asking whether he meant she was crazy. He recorded her telling him the doctors had never examined her. He recorded that he would not leave the room while she dressed because he thought she might go out of a window. A man covering something up does not write that down. Which leaves you with the harder possibility. Leonard Swett went home that night and wrote an honest account of a thing he believed was necessary and correct. The honest account is the most damning document in the file. Isaac Arnold, the lawyer who called no witnesses, spent his last years writing a life of Abraham Lincoln. He died in 1884, and it was published after him. It is a serious book, and it is still cited. He had nothing to say about the afternoon he spent representing Lincoln's widow. Dr. Patterson kept Bellevue Place. He had been publicly attacked in the Chicago press for his handling of the most famous patient he would ever have, and he wrote to defend himself, and his position was consistent to the end. She was ill, she was well treated, and her release was a mistake made under pressure from a newspaper. He may have been right about the first 2. Myra Bradwell kept publishing the Chicago Legal News, kept lobbying, and kept being refused a license to practice the profession she had passed the examination for in 1869. Illinois finally admitted her in 1890, on the court's own motion, without her asking, and backdated it 21 years, so the record would show she had been a lawyer all along. She had 4 years left. She was admitted to the bar of the Supreme Court of the United States in 1892, 19 years after that same court told her that a woman's paramount destiny was to be a wife and mother. She died in 1894. And Mary Lincoln, after the reversal, wrote down what she thought Myra Bradwell had done for her. It is the warmest thing she wrote about anybody in the last decade of her life. She wrote that all others failed her in the most bitter hours of her life, among them her husband's supposed friends. These loyal hearts, she wrote, came to her assistance and rescued her, and under great difficulty secured her release from confinement in an insane asylum. There are 2 transcriptions of that sentence in circulation, and they differ slightly, so take the wording as close rather than exact. Take the content as exact. She named the people who came. The list was short. So, what was actually decided on the 19th of May, 1875? Not whether Mary Lincoln was ill. She was ill, and she had been ill for years. And by 1882, 4 physicians could name the columns of her spinal cord that were failing. Not whether her son loved her. He did, and it cost him money, and it cost him his mother, and he never publicly explained himself for the remaining 51 years of his life. What was decided was a much smaller and much more frightening question: whether an institution with every modern safeguard switched on could, in a single afternoon, on 17 witnesses and no defense, correctly distinguish a grieving woman with a neurological disease from a mad woman. And it could not. It got the answer, and the answer had the force of law, and the answer was wrong about at least one thing on the paper in a way we can prove. Because remember the form. 12 men filled in the blanks. Age, 56. Duration of the disease, unknown. Cause, unknown. Not hereditary. Not epileptic. Not a pauper. And in the space, asking whether she showed any homicidal or suicidal tendency, they wrote that she did not. Within hours, she was standing in a Chicago drugstore, drinking a bottle of sugared water, in the certainty that it would kill her. They were not lying. They were not careless. They had been given 3 hours of evidence by people who wanted a particular outcome, and no evidence at all by the one person paid to give them another, and they answered every question on the form. The form did not have a blank for what nobody told them. Elizabeth Packard built that hearing to make sure a woman could never again be disappeared on a husband's signature. She succeeded. Mary Lincoln got the jury, the lawyer, the public courtroom, and the printed verdict that Packard had spent years fighting for. She got all of it in one afternoon, and it took 10 minutes, and the transcript of what was said has been missing for 150 years. Nobody knows when it disappeared. Nobody knows how. So this is what is left of the trial of Mary Lincoln. The record of what 12 men decided is still in a county file in Chicago, with every blank filled in. The record of what anybody actually said is gone.